All right, so hello everybody. My name is Galia Aharoni Schmidt. I am the founding attorney at Aharoni Business Law. We call it ABL a lot. So ABL is based in Oakland, California, but we help businesses all over the world really who do business in California or sometimes with things like trademarks just throughout the United States. So what we do at ABL is basically try to help business owners sleep better at night by making sure their assets are protected, and we try to minimize the risk of lawsuit and protect their stuff so they know that their kids' college fund and their retirement fund and their house are protected, so they know that they can be successful in business and not have to worry about that extra stress. So we do a lot of forming new businesses for people. We do a lot of helping people hire people, including working with contractors, and also a lot of trademark issues and other intellectual property issues. So kind of just any kind of general counsel issues we can help you with to make sure you achieve your success. So you are watching this webinar because you heard that California just came out with a brand new law about independent contractors. And the state has become increasingly aggressive around this issue, and it's become harder and harder and harder to be a contractor or to hire a contractor in California. And it was already hard even before this new law. So I know there's a lot of fear and confusion right now about this issue. So that's why I wanted to give this webinar, to walk you through the new law, figure out how it might affect you. So whether you're the contractor or you're the person hiring the contractor, hopefully after this webinar, you'll know where to go from here to protect yourself and make sure you aren't at risk without even knowing it. So hopefully after this, we can avoid some lawsuits for you, we can avoid some audits for you, and you can do business without stress, again, knowing that you're doing the right thing. So this is a beginner's presentation. I've written this for you, assuming kind of a limited or just basic knowledge of contractor law and employment law in general. So heads up if you feel like you're already an expert on this. One thing I am going to do is beginning of next year, probably around February, I am going to do a more advanced version of this talk, and I am in the process of getting CLE certified. So if you're an attorney and you're watching this, you can also check back in February and get some CLE credit if you want to pop back later. So if you want to know more about that, you can sign up for a newsletter or follow us on Facebook, things like that, and get some information about when that's coming up. So this is the California law. I am assuming that the workers we're talking about are in California. Some of these laws might still apply if your workers are out of state. So if that's a question you have, assume it applies, but that's a good question to talk to me or another lawyer directly about to make sure we can look at that specific worker and figure it out for you. So I also can email the slides to you at the end. I'm going to give you the contact information and tell you how to do that. So don't worry too much about taking a ton of notes. But in the meantime, I think that's it. Let's dig in. Okay, so before we even get started, I do want to talk about just some foundations to keep in mind as we're having this conversation. So first of all, why is this even important for us to talk about? People are using contractors more and more and more. I think we've all heard the phrase, the freelance economy. That's what's going on now. A lot more people are starting their own businesses as freelancers. A lot of businesses are hiring freelancers instead of employees. But the law is changing, and we need to be aware of what the law is so we don't accidentally break it and we don't accidentally get in trouble and get sued or get audited. So these are just a few things to keep in mind before we get into the law itself. So first of all, what even is an employee? Because we need to know what an employee is to understand the difference between employee and contractor. So an employee, and this is just broad strokes, generally speaking, an employee is somebody that does work for money for a company, and the company has a lot of control over the employee's work. They can tell the employee what to do and how to do it and when and where to do the work and all of that. They have total control, of course, within the law about the work that the worker is doing. But the flip side of that is there are a ton of laws that apply as soon as someone's an employee. So these are things like minimum wage, like overtime, like lunch breaks and rest breaks, also requirements for paying for unemployment insurance, workers' comp, all of those things. So you get a lot more control over them, but they're a lot more expensive. And also your risk of lawsuit is a lot higher because there's just a lot of laws that now apply that maybe wouldn't otherwise. So on the flip side of that, it's the opposite. If you have a contractor, the company hiring the contractor is supposed to have very little control over the work that the contractor is doing. So really, when you're hiring a contractor, you're really only supposed to have control over the end product. You hire them to produce a result, and they give you that result, and you don't really have a lot of control over how they do it, or the tools they're using, or when and where, and all of that. So the flip side of this, though, is a lot of those employment laws do not apply. So you don't have to worry about minimum wage and breaks and overtime and workers' comp and all of that stuff. So they tend to be, there's a lot more flexibility on both sides of that relationship, and just potentially less liability for the employer as well. So generally, why would someone want to work with a contractor instead of an employee? An employer wants to use a contractor, again, because maybe possible, there's fewer laws that apply. So possible less liability, less risk of breaking one of those laws, less paperwork, and less overhead, because you don't have to be paying for employment taxes and unemployment and workers' comp, all of that stuff. A contractor wants to be a contractor generally because they get more independence. They get to decide their own schedule and how much work they take on and what their rates are. And they just have a lot more autonomy and independence and flexibility over their lives. And that's something that people, especially lately, have grown to really care a lot more about. So that's the context here, employee versus contractor. So one thing you need to keep in mind during this whole conversation is that no matter what situation we're talking about, there is a legal presumption that the person is an employee. The state wants the worker to be an employee. So if you think someone should be a contractor, it's up to you to meet these tests and to structure this relationship to be able to counter that assumption and prove that this assumption shouldn't apply. So always, we're fighting an uphill battle here because there's an assumption that the person's an employee, and the burden is on you, the company, to prove that they're not. So the word misclassification is going to be thrown around a lot probably. That just means the classification of someone as an employee or the classification of someone as a contractor. So if we say someone has been misclassified, what we're usually saying is we've been treating them like a contractor, but really the government would consider them having been an employee the whole time. So that person's been misclassified. So if you get in trouble for misclassification, we'll talk later about the consequences, because they can be really big. So, and why does the government want people to be employees? They, first of all, want to protect people. There are people who do try to abuse these rules and try to take advantage of people by hiring them as contractors when they really should be employees. But also the state makes more money off of employees, and they have more control over all of us if the person's an employee instead of a contractor. So, they want their taxes, they want everyone to have workers' comp, all of those things. So they threw out this pretty wide net and made a lot more people employees instead of contractors. So the other thing to keep in mind is that there are situations in which this new law, AB5, doesn't apply. And we're going to talk a lot about that. But remember, if the new law doesn't apply, it doesn't mean it's a free-for-all in the Wild West. It means the old rule applies instead. So all that said, we do need to talk about the old law before we can talk about the new law. And it is still relevant. This law still is in place. And like I said, if the new law doesn't apply, this law does apply. So we need to remember what this law is as well. So before AB5, most of the classification issues we're talking about were governed by a case called Borello. So the way that Borello worked was the entire test was designed to figure out how much control the business had over the work that the contractor was doing. So the reason this was a little more flexible was because the Borello test was it was a little more squishy. You had more room for argument because we're going to go over all of the factors from the Borello test, but not every single one of these factors had to be satisfied in order for someone to be a contractor. There was wiggle room. You can make an argument either way. If one factor wasn't hit, it's still possible this person could be classified as a contractor. So still a difficult test to meet, but flexibility involved. So no single factor makes it a yes or a no. So let's talk about Borello. So number one, again, we're looking at the entirety of the circumstances here. Number one, does the business have the ability to discharge the worker at will without cause. And so, we're talking about who can end the contract, who can end the relationship, and when. And does there have to be a reason to do that, or can anyone just quit or fire the other person at any time? So if the company can basically fire the contractor at will without cause, that looks a lot like employment. So what the government wants to see is very specific time-limited or project-limited projects for contractors that end at a certain date or upon completion of the project. So if it goes on forever and either party can terminate at will for no reason at all, that looks like employment. And the reason is, if the contractor is worried about getting fired all the time for any or no reason, that suggests that the company has control over the work that the contractor is doing. So that's a big one. The next one is whether the worker is engaged in a distinct occupation or business. And I've bolded this one because it's going to come up a lot in a big way later too. So basically the government wants the worker to have their own business, and they want the business to be doing something that is different from what the business's company does. So if they have their own business, they're going to look a lot more like a contractor than an employee. Number 3, they're going to look at the kind of work that is being done, and is it usually done with direction and supervision, or is it usually done by a specialist without supervision? So again, this one seems kind of obvious. If it's usually done with direction and supervision, that looks like an employee. If it's usually done by a specialist on their own without supervision, that looks like a contractor. Number 4, they're going to look at the skill required in order to do the job that the contractor has been hired to do. So generally speaking, the more skill the person has, the more it's going to look like a contractor, but this is going to be very, very much based on the circumstances, as all of these are. So it's going to look at exactly what the contractor is doing and how much skill is required. They want you to be hiring someone who has skills that you don't already have, or that an employee of yours would already have. So the next one is an opportunity for the contractor to create their own profit or loss depending on their own managerial skills. So what that means is, so you can kind of contrast it. As an employee, the employee is working 40 hours a week and they're making a salary or even hourly, but with a set schedule. And they don't actually have a lot of control over making more money or less money. They get paid by the hour and they get paid their salary. And no matter how efficient or not efficient they are, they still make the same amount of money. They can make more work for the business. They're not necessarily seeing more of that money. So a contractor, on the other hand, decides how many clients they want, decides how much they want to work. They set their own rates. They decide what they're doing, for whom and when. They decide what tools they're using and how much that's going to cost. They have control over how much efficiency is built in, all of that. They have control over their bottom line and whether they're making a profit or a loss. So the more control they have over that, the more it's going to look like they're a contractor. The next factor here, and these are the rest of the Borello factors, number 6 is who provides the tools and who provides the place of work. So a traditional contractor relationship, the contractor provides their own tools unless there are very specific reasons why they can't. So, if I have a plumber come to my office and fix my sink, I can't tell them you have to use these tools that I'm providing you. They're going to bring their own tools, obviously. So same thing, place. If you hire me, you can't force me to come work in your office when I'm doing work for you. I can choose to if I want to, but it's up to me. I'm the one who decides where the work is done. Unless, again, there's a very specific reason. So there's security reasons, or obviously the plumber has to come to my office because the sink is broken in my office. So he or she has to come over. So number 7, the worker's financial investment. This is related to factor number 5, but the government wants to see that the worker is the one who is buying tools, who is buying equipment. They've put some sort of financial investment into creating the business and running the business. If that burden is on the worker and not on the company, it's going to look a lot more like a contractor. Length of time is the next one. The longer the contract is, the more likely it's going to look like an employee. So a lot of times we'll see these kind of ongoing contracting relationships with no end date. And those are going to look a lot more like employment and are going to be a lot harder to defend because that's not what the traditional contractor type role is or should be. So generally, if we're doing a contract for a contractor, we are going to have it be per job. So, this contract ends automatically at the conclusion of this goal that we hit, this result that we've done for you. Or, I'm going to do consulting for you for 2 months. And in that period of time, then it expires, and then we're done and we move on to the next thing. So if it's per job, it's going to look more like a contractor. If it's indefinite or a very, very long time, it's going to look more like an employee. Method of payment is kind of similar in that you've got this traditional employee payment. So, employees generally are going to get paid by the hour or just a regular salary every 2 weeks, and payroll just gets run. A contractor is not really supposed to be like that. Some situations it is okay to pay them by the hour, like your traditional CPA or attorney relationships. It's normal to have them be by the hour, but you still hopefully want it to be project-based as much as possible. So typically we like to see just, one flat price for a particular job, billed by the contractor at the beginning or end, sends an invoice, and then the business pays the contractor. So we don't want to just see hourly work paid out every 2 weeks, just like an employee. That's going to look a lot like an employee. Number 10 is also bolded because this is also going to look familiar coming up soon. They want the work to be outside of the regular course of the company's business. So if I am a law firm and I'm hiring an admin to help me, that admin is probably going to be doing things that are in the normal scope of my business, like opening up my mail or answering my phone. But if, again, I'm hiring that plumber to come in, clearly fixing sinks is not something that I do. So that's outside the scope of my regular business. If the worker is doing something that an employee would normally do, and that's within the scope of what you usually do in your business, that's really going to look like an employee. And finally, we're going to look at what do the parties believe? Does everyone believe this person's a contractor, or does one party think that they're actually an employee? So that's a really important factor when we're deciding. Well, it's a good idea to have a written contract, because a written contract is going to cover a lot of these things, but it's going to make it very, very clear that both parties agree that that this person is a contractor. So again, when we're passing this test, you don't have to satisfy perfectly every single one of these factors. We're going to weigh all of the factors together, and there is a little flexibility involved, but it's still a very hard test to meet, and you're still starting out with that presumption of employment. So keep that in mind. It's still difficult, but there is a little more wiggle room built in. So with that background in mind, let's talk about the new law. So the new law is called AB5, and the test has been commonly referred to as the ABC test. So it's just signed into law. Basically, it codifies and expands the test from a case that came out in 2018 called the Dynamics case. So the Dynamics case was the case that came up with this ABC test. And this law is just making that, it was passed by state Congress and made a law by the governor, and this is now going to be the law for this. So it's becoming, most parts of it, for all intents and purposes, are effective January 1st of this coming year. And again, we still have this presumption of employment, but the difference between this test and the Borello test is that all three of these factors have to be met. Otherwise, this person is an employee. So there's no wiggle room. It's harder. There's much less flexibility. So kind of the reason why it's happening now is because, in my belief at least, because of this freelance economy, and the government's become really uncomfortable with these changes in our economy. And there are companies like Uber who are the reasons why this law has been passed. They're really going after the Ubers of the world who are taking advantage of these laws. Whichever side you come down on Uber, there is gray area about whether their drivers would actually be considered contractors or employees. So the government doesn't think so, and the government doesn't want them to be contractors. They want to protect these people. And in the meantime, I believe they set this net and accidentally, or maybe on purpose, set too big of a net and those of us who are working with contractors or who are contractors have kind of been caught in this net that we don't want to be caught in. A lot of contractors want to be contractors. So it did expand the law to apply to situations where basically every situation now where classification is questioned in California. So, so let's dig into the 3 factors then. So factor A, the company does not have the right to exercise control or direction over the worker's services. So this probably sounds familiar, hopefully. This basically wraps up the entire multi-factor tests that we used to use before, including Borello, and there was other tests too. So this looks at the right to control the worker, not whether you're actually controlling the worker. So they're really looking at, again, does the company have control over just the result, or do they have control over the method and means that the worker is using to get to that result? So again, plumber is the example they love to come back to over and over again. I control the outcome. I say my sink is broken, fix it. I cannot tell the plumber even when to show up at my office, and I can't tell them what tools to use, and I can't tell them how to do it, and I can't tell them if they can bring an employee with them. I can't control anything that they're doing. All I can do is say, I need this result. He or she gives me that result. The flip side of that is, of course, again, our administrative assistant. If I have someone come, if they're answering phones for me, then they have to work certain times. And if they're greeting people at the door, they have to be on site. And I'm probably going to tell that person how to answer the phone and what work to do and when, because it's kind of hard for an admin to not have that direction. There's not a particular goal in mind. It's just kind of ongoing work. And I am going to want to be able to tell him or her how to do the work in order to do it. I'm going to have control over them. So again, we can look at some of these factors again. Some facts to look at. Again, can they be fired at any time and for any reason? Are they paid by the hour or per project? Do they provide their own tools? Are they doing skilled work? How much instruction and training is required in order for them to do it? If it requires a lot of training, that probably means they're an employee. I'm training my admin. I'm not training my plumber. How long are they working? And do they think they were a contractor? So these factors all should be very familiar. They all came from Borello and all of the tests that came before. So when we're talking about this particular factor, again, no single fact is going to make it a yes or a no. We're going to look at the whole, but if enough factors look like employee, this whole test will fail. And this person is going to be an employee and not a contractor. So the assumption is employment, and it's already a hard burden to meet. So again, some more examples of this, of right to control. So I had a client years ago who did corporate team building and scavenger hunts. And so they had just like a really big listserv of all of their potential actor pool, and they would just shoot an email out to everybody and 200 people and say, does anyone want this gig? You have to show up at the library at 2 o'clock and say this one sentence if people show up. And so one of these actors had done maybe 5 gigs for them ever, made a few $100, and was filing an unemployment claim for a different job and had listed them as one of his previous employers. Accidental. He didn't understand that he wasn't supposed to list them if he was a contractor. Suddenly the client gets audited and went through a whole hearing and everything. And this person was found to be an employee under this old test because they told him when to show up. They told him where, they told him what to say. And so it didn't matter that he just worked whenever he wanted to and took whatever gigs he wanted and decided whether to take the gig and only made a few $100 and only worked for a couple hours. It didn't matter. That was enough control to show that they had enough control over him to classify him as an employee. So that's how wide this net is. We also see it a lot with acupuncturists, yoga studios, the old school kind of traditional model where someone owns the business, but they have contractors coming in to perform the services. This is a lot more difficult to do now. And so last example, I had a client who you know, their marketed business model was that they provided doulas and nannies to, you know, young families with new kids. And the doulas had been classified as contractors. But there was a kind of unofficial training that these doulas needed to do and the weekly meetings. And technically they were optional, but really it was questionable whether it was optional or not, and that's not going to look good. That looks like they have control over what the worker is doing, and also probably too much training involved, even if it's an optional training. So that is factor A, control. Factor B, the worker's services are outside the company's usual course of business operations. So this should also look familiar, but now it's a yes or no test. Do they or don't they? So basically, the contractor should not be doing work that the hiring firm normally does within the normal scope of business. Again, a plumber is outside my scope of business, my admin is not. Is the work they're doing related to the core business that the business is performing? So this is not actually as straightforward of a question as it seems like it should be, because it comes down to the definition of what you actually do. And this is actually where the Uber case becomes, this is the factor that it's coming down to. Uber is saying, we don't provide rides to people. What we do is provide a software platform that connects drivers with riders. And the people on the other side of the case are saying, are you crazy? Ask anyone on the street what Uber does, and they say, you provide rides to people. So, question one is, how do you define your business? The question two is also, are we the ones that get to decide? Is someone else going to be able to come in and say, actually, you say you do this one thing, but you're actually doing this other thing? And how do we actually define the parameters of what we do, and how much of that is just in how we present the work that we're doing? Same thing with that doula company. Do they say we provide doulas and nannies to you, or do they say we are a concierge service that provides a platform where we link up doulas who are qualified with families who need them? It's a subtle difference, but it's one that could make a really big difference in this context. So if I'm hiring a lawyer as in an assistant role to do work for me, that's probably within the scope of what I do. But if you're hiring a lawyer, that's outside of the work that you're doing. You're hiring them to give you legal advice. So a lot of this is context. And you have to ask yourself what services you actually do provide. So like I said, there is a lot of ambiguity here, and I'm really curious how this is going to play out over time. For example, the easy examples, again, someone hires an admin to open mail. That's within the scope. But what about a copywriter and an ad agency? Is copywriting something that, depending on the ad agency and what they normally do, is that going to be a key part of the services they're providing? Or if it's something they always outsource, does that count? What if that copywriter has their own business? But what if they're on Fiverr instead? Does that count as them being independent enough? What about a wood finisher and a custom cabinet making company? The cabinet company is making cabinets, but does that count as a regular part of what they're doing? It's not always clear. So I think there will be lawsuits here, but one thing I want you to ask yourself is, what actually are the things that are within the usual scope of your business here? All right, and finally, we've got factor C. So, is the worker engaged in an independently established trade, occupation, or business? So again, basically, the worker is supposed to have their own business, and if that business is supposed to exist separately and independently of the relationship they have with the company. So the government wants to see that this business is stable and lasting and will survive even after the relationship that they have with the current client ends. So we're going to look for things like, do they have other clients? Are they working full-time for this client or not? Do they have specialized training? Do they have their own website? And we'll go into a few more of these as well. So again, the government really wants these super traditional contractor relationships like your plumbers and your accountants and your electricians. But again, we've still got ambiguity here. And there will be lawsuits. So again, okay, so some factors to look at. Do they have a separate office? Do they have their own website? Are they listed in the phone book? Do they have their own employees? Do they have a financial investment in the business? Do they have their own insurance? Do they have their own workers' comp? Do they have more than one client, or are you their only client? Do they have a business license? Do they file a business tax return? Do they have their own equipment? Are they paid per job or by the hour? So a lot of these, again, should sound really familiar, but we want to make sure that if we are claiming that someone has their own business, they really do actually have their own business and it's not just kind of a sham. So more examples. There are a lot of contract paralegals who help lawyers out and law firms out. So, so if a paralegal just doesn't have a job and they're just doing work for one firm and that firm has a lot of control over what that paralegal is doing, that's not going to look like that paralegal has their own business, even if they're claiming to have their own business. But if that paralegal has 5 clients and they have a website and they have their own business cards and the firms don't really have a lot of control over the method of doing their work, you know, if I just hired a paralegal and said, hey, I need some bylaws, they'll send me some bylaws and I'm not providing them any tools. I'm not telling them what software to use. I'm just buying that and I'm then working on it myself before I'm giving it to a client. You know, it's very, very fact-based, all of these. So, so still the ambiguity here is, do people like workers on Fiverr count as having their own business? How much due diligence do we need to do to figure out whether somebody has their own business or not? If the consultant only has you as a client right now, but it's necessary to their work, is that going to be still hard to prove that they have their own business? So there will definitely be lawsuits to clarify this factor too. There are questions like, if someone has an incorporated entity like an LLC or corporation, does that automatically exempt them from the ABC test? We don't know. If they have their own business, does it affect the interpretation of factors A and B? Like, would they give more wiggle room in our copywriter Fiverr example, for example? I don't know. So that's one thing that's pretty frustrating about this rule, is that there are a lot of questions still open, and it's probably going to be 10 or 20 years before a lot of these questions get litigated and we find answers to them. So that's frustrating, but that's where we are. So those are the 3 factors for the ABC test. So all 3 have to be met for someone to be considered a contractor. So with all of that in mind, we've got Borello, we've got the ABC test. Now I want to talk about some of the exemptions to the ABC test, because I hope all of you were with me with the ABC test and understood everything I was talking about. It's not that complicated. There definitely are still questions involved, but we at least can get what the state is going for. But this new law came with a ton of exemptions. And the exemptions are even more complex than the test itself. There's a ton of ambiguity, complexity, confusion baked right into these exceptions, and they're not straightforward at all. So I wanted to talk about, I'll talk about most of them super quickly. There are 2 that I think will come up a little bit more in just day-to-day work life. So I wanted to focus on 2 in particular. But I want you to remember that if these exemptions apply, that doesn't mean, again, it's a free-for-all for classification. It just means Borello applies instead of AB5. So that's why I wanted to go over Borello with you. So let's talk about the many exceptions. So this list here is a list of the exceptions for specific industries. So generally speaking, the ones on this list right here all need licenses given by the state of California. So we've got lawyers, we've got insurance brokers, doctors, dentists, psychologists, vets, architects, and licensed engineers and accountants. So there might be some architects on this call, for example, right now. They've been calling me a lot because architects as an industry tend to use contractors a fair amount. And if you're working with a licensed architect, then this exemption may apply, which means Borello would apply instead of AB5. So that doesn't mean that you can treat them however you want, but it just means you might have a little more wiggle room and Borello applies. So feel free to shoot a message in the chat box if you want, if you have questions about any particular of these, but generally that's, you know, these particular industries may have exceptions. So other ones, we've got specific exemptions for construction subcontractors, real estate licensees, businesses that obtain work through referral agencies. So referral agencies, we're really talking about companies like Rover, TaskRabbit, kind of those errands or furniture assembly businesses or animal services, dog walking businesses where, the contractor is maybe signed up on the website and the website hooks people up. People can go on and pick the contractors. So if you want me to talk about that one, also send that over in the chat box and let me know, but I assumed that that's probably not the most relevant to you all. Commercial fishermen also have their own. So there's two specific exemptions I wanted to spend a little bit more time on. The first one is the professional services exemption. So this is a kind of two-step dance we're doing here. First is this exemption only applies to these specific professional services. So, going down the list quickly, we've got marketing professionals, but again, this is really kind of unclear what they mean by marketing. It says it has to be original and creative work, but it's kind of still unclear what counts as marketing under this exception or not. Same thing with HR professionals. It does say the work has to require some judgment and discretion on the worker's part, but still not super clear. They just don't want it to apply to kind of someone who's just running payroll or doing admin tasks, but there's probably going to be lawsuits about this. Travel agents, graphic design, grant writers, fine artists. If you can tell me what fine artist means, that would be really helpful, but so far not super clear. Enrolled agents who are registered with the state, payment processing agents, still photographers with a lot of extra restrictions, freelance writer, director, editor, or not director, just writers and editors, or newspaper cartoonists. Some of these do have extra rules, like the last few there. So still, if you're in this list, it doesn't necessarily mean it's a free-for-all, but just pay attention and make a mental note to yourself that you should talk to an attorney about this. So the other professions that this exemption applies to: licensed estheticians, electrologists, manicurists, barbers, cosmetologists, if these people also satisfy all of these other tests. So they need to set their own rates and process their own payments. They need to set their own hours, have their own book of business, schedule their own appointments, have their own license, give 1099s. So if they're one of these professions, and also if these professions satisfy those rules, then Borello might exist if this person also has a separate business location, a separate business license, they set their own rates, they set their own hours, they have other clients, and they use discretion in performance. So again, you can see how complex these exemptions are and how it's really not straightforward whether it applies even to the people that are listed in this exemption. So, and again, if we are passing this really complex test, we're just using Borello instead of AB5. So there you go, professional exemption. The other one I think is going to be used a lot is the business-to-business exemption. So again, we're using Borello instead of AB5 if all of these factors are hit. Number one, there has to be business entities on both sides. So working with each other, having a contract with each other for one business entity to do work for another. So the business service provider, the person doing the work as a contractor, has to be their own business entity. And so this entity can be a sole prop. It doesn't have to be an LLC or a corporation or a formal entity. It can be a sole proprietorship or a general partnership, but it has to actually be a separate business entity. So that the business service provider, again, has to be free of control and direction from the contracting business. And one of the key factors here that I think is going to be really important is the service they're providing is to the other business, not to the business's customers. So that can be, I think that's going to be a really important one when someone's trying to apply the B2B exemption here. So take a look at that. If you are a business providing services to other businesses, make sure you're providing the work to the business and not actually to their clients. So also, again, this test does not apply to an individual working for a contracting business. So if you've gotten your contractor from a contracting business, this doesn't apply. We're talking about business to business. And so if it's anything other than that, we're going to be using the ABC test. So these are the other factors to look at to figure out if the business-to-business exemption applies. There has to be a written contract. So this is a new factor, and it's new that this is a requirement. So if you're going to claim this exemption, there has to be a written contract between the parties. And this is also new, there has to be a business license. So again, if we're just a sole prop, that's fine, but the sole prop has to have its own business license, and there has to be a contract between the two. And side note, a business license, that's just the license you need when you're to register that you're doing business within a particular city. So my business is based out of Oakland. I have a local Oakland business license. If you have multiple locations, you might or do business in lots of different cities, you might have to get more than one. The state wants the business, again, to have its own separate location. That doesn't mean that you can't work on site if there's a reason to, but there just has to be a separate location. That separate location can be the business's home office. You can work from home, and this business-to-business exemption can still apply, but generally there at least needs to be a place that's separate where the business works, the contracting business works. Again, we're going to want to see that they're customarily engaged in in an independent business of the same nature of work performed. So they just want this business to actually do this thing for a living and for other people. And they want to see actual contracts with other businesses, other clients for similar services, and then no restrictions on working with other people. So there's still more. We're almost there. So the business needs to advertise their availability to provide similar services. Again, things like websites, brochures, ads are going to be helpful. They need to provide their own tools, negotiate their own rates, set their own hours and location. These all should sound familiar. They're from the other tests before, but now they're required. All of these have to be hit in order for this exception to apply. So that means that this classification of whether this exemption applies can come down to something simple, like whether they have a business license or not, or whether there's a written contract or not, because every single one of these has to be hit for the first time. So this does not, by the way, apply to businesses that have contractors' licenses. There are other exemptions that may apply to you. So that's a lot. That's all the time I'm going to spend on exemptions right now. But if you feel like one of those might apply to you or to workers you're working with, don't make any assumptions about whether the exemption applies. Don't just assume that because I'm working with an architect or whoever, that this exemption applies, especially one of these complex ones. So please just talk to a lawyer if you feel like any of these might apply, because I don't want you to accidentally apply the wrong test and then get sued or get audited. These are really complex, and I don't want you to get in trouble by accident. So, but for the most part, I just want you to keep in mind that these exemptions are even more complex than the rule itself. So all of that said, this is the part where I have to scare you a little, because it all sounds complicated and like a huge pain in the butt, and nobody wants to do all of this compliance. It's easy to want to avoid having to go through all of this. It's a pain, and it's complex and confusing. So I want you to just understand the basics of what could go wrong if you don't follow these rules, because I need you to know what's possibly at stake. So generally, if you don't pass one of these tests, whichever one applies, if the worker doesn't pass the test, they're considered an employee under the law. That means you would be on the hook for minimum wage, sick leave, overtime, breaks, unemployment, all of that stuff. And you will be responsible for all of that retroactively too. If you've been treating them like a contractor for years, but they were actually an employee, you're going to have to pay that probably going back 3 years. So it can get really expensive if you don't. There are multiple places that can come after you and get you in trouble for this. So first of all, just individual workers can come after you. They can sue you for minimum wage violations, missed meal and rest periods, reimbursement for business expenses, failure to provide accurate wage statements, unfair business practices, a long list of things they can sue you for. And they can sue you individually, or they can sue you as a class if you're working with lots of them. So that's one way we're going to get just dragged into court individually from workers. The other is state agencies. So there's a lot of agencies to choose from, and they all have their own interest in this. So we've got the EDD caring about unemployment. We've got the Labor Board, the DLSE, caring about employment taxes and workers' comp, and things like that, wage and hour violations. There's the Franchise Tax Board, who cares about taxes. There's the Workers' Comp Board, who cares about workers' comp. State licensing boards, all of them. They all have their own interests, and they all can audit you, and they all can come after you and penalize you, and they can all come after you separately. So there's possibly a lot at stake here, and they can all also generally come after you without provocation. They don't need a tip off. They don't need someone to tattle on you. A lot of them can just say, hey, we're going to start looking at acupuncturists this year, and send letters and audit everyone. I've seen it happen. So not great. This new law, the ABC test and AB5, also authorized some attorneys general, and city attorneys to come after and bring lawsuits against people in certain cities as well for certain things. I'm assuming this is not going to be used against very small businesses. And if you're in a smaller town, probably won't apply to you, but they have more power. And again, in these situations, they don't need a tip-off. They can just decide to do it on their own. So there's lots of ways you can get in trouble for this. And also keep in mind, they make it very easy for a worker to tattle on you and a lot more difficult for you to defend yourself if you're the business. There is a lot at stake here. And in my example from before with the workers' comp or the unemployment claim gone bad, a lot of times it does come from an employee, but it is an accident. So those are things we just can't control for. So if you were audited or sued, what's the damage? Number one, fines and penalties. They can slap big penalties on top of anything that you already owe, which would be back pay, back benefits, back taxes, and withholdings. So anything you would have paid that person, including all of their breaks and overtime that they would have made, you are going to have to pay them, plus penalties and fines on top of that. And those penalties are bigger if they find willful misclassification, which they almost always do. And again, you can get hit from multiple places at the same time. There's also potentially civil penalties up to $25,000 per violation if there's willful. So I have seen successful businesses have to close their doors after getting $80,000 or more in penalties. It can be very painful. So keep the consequences in mind when you decide how to handle this new law. There's also some other implications that people don't usually think about. Ownership of intellectual property might be at stake depending on whether the person was an independent contractor or an employee, because the laws on who owns what that's created is different for both. Again, potential workers' comp issue, if someone's classified as a contractor, gets hurt, and then tries to get that covered, there might be misclassification issues that come up. Same thing with employment and unemployment. And also potential liability for the worker's actions. Let's say worker was a contractor, classified as a contractor, but gets in a car accident while they're doing a job for you. The person who is going to try to collect from them is also going to claim probably that they actually were an employee, and you may or may not then become responsible for their actions if they were misclassified. So possibly big stuff at stake here. So do keep in mind there are a couple situations when the ABC test doesn't apply, mostly for things like federal taxes. The IRS has their own test, closer to the Borello test. Also doesn't come in mind when we're figuring out whether you have 50 workers for the Affordable Care Act. But generally, assume this test applies. Even these tests are still very pro-employment, and they can be costly. So knowing everything that we've just learned, we have the basics. It's time to take action. I want to make sure that you are protected, and I want to help you avoid lawsuits, avoid audits, avoid those $80,000 in penalties, and avoid misclassification, whether on purpose or by accident. So what do we do now? Number one, I encourage every single one of you to do just a self-audit on what we've learned today and figure out whether you think the worker is a contractor or not. And be honest with yourself, because again, we're fighting an uphill battle with the assumption that the person's an employee. So if you're a contractor, try to go through it. And if you want to stay a contractor, make sure you have a conversation with your clients about whether you need to change the relationship at all. If you're working with contractors, for contractors you already work with, let's take a look at the test and figure out if they should be reclassified as employees. And if you're bringing on new contractors, figure out for every single one of them how they should be classified. Sometimes we might decide that this person actually should be converted to a formal employment situation. So in that situation, we might have to change their job duties. We probably have to adjust their pay, probably down, to factor in the extra cost of them being an employee. There are some IRS settlement programs and relief programs if you're worried about getting in trouble for this retroactively. There is relief, but it is a big thing to convert workers to employment, especially if you don't have any employees already. And again, if we're keeping someone as contractors, let's try to make sure we are hitting every single one of those factors in whatever test applies. So again, don't assume, please, that an exemption does apply without talking to a lawyer. It can be me, it can be someone else. Just make sure they're familiar with this law. The exemptions are very complex, and even a lot of lawyers are not fully up on the exemptions yet. So if you saw your type of business on that list, talk to a lawyer, see if one of those may apply, and have them help you with the analysis. There are going to be a lot of people who are willing to take a risk. You know, it is expensive and burdensome and a pain in the butt to switch people from contractors to employees, and some people frankly just can't afford it. And the options are keep someone a contractor or not have any help at all. And so while I can't necessarily recommend doing that, especially if you know that this person should be classified as an employee, some people are comfortable with risk. And if you know that that risk is there, then that's, I think, a decision a lot of people are going to make under this new burdensome rule. And a lot of people likewise are just kind of waiting and seeing. We don't know how this law is going to change over time and how to interpret it. The court might delay implementation of certain bits of it while court processes play out. A lot of industries are going to try to add on their own exemptions, and there are a lot of cases already in court. So, you know, a lot of this might change over time, but it's up to you whether to decide whether to be one of the potential use cases here if you want to end up in court making the law. I personally am risk averse and wouldn't want to be made an example in the state, but you know, somebody's got to, and that, you know, it could be you. So what can ABL do to help you with this process? We can help with that classification analysis. We can look at every single example of contractor relationship you have, see if the Borello test applies or if the ABC test applies, and if one of those exemptions applies. If the person's going to stay a contractor, we can help you draft that contractor agreement, which of course is going to be especially important if you're trying to fit into that B2B exemption. But if we look at it and realize that, you know what, there's so much gray area here, it might be better to convert all of these workers to employees, we can do that. We can help you with that as well, and make sure you know all of the now new employment laws you need to comply with, and make sure you're not accidentally breaking those as well. If you are a contractor and you want to be able to fit into that B2B exemption, we can help form business entities for you and help make sure you get your business license and all of those things that are going to help you qualify for that B2B exemption. And we also, just like I said at the beginning, provide ongoing general counsel services. So anything that comes up, formation, contracts, employment issues, trademarks, website stuff, all of those things we can help out with. So this is my contact information. If you want a copy of the slides, please send us an email at office@aharonibusinesslaw.com. You can also sign up for a newsletter if you want to get more information about upcoming programs. We are going to have a white paper on this issue, independent contractor classification, come out in the next few weeks, and that'll be on our website, and we'll blast that as well, that it's up. There is a shorter primer on contractor law right now on AB5 on our website right now. If you go to aharonibusinesslaw.com and then go to articles, please feel free to send this video to anyone you know who freelances or works as a contractor or works for contractors. We're going to have it up on our YouTube page within a week. Again, if you follow us on YouTube or Facebook or the website, the newsletter, any of those places, you'll know. And we do try to do these, we do webinars every couple of months, but we do try to put videos up on our YouTube channel once or twice a month at least. And we're trying to do even more of those to just give you some free guidance. So you know when you need us and you know when you don't. So feel free to subscribe to our channel on YouTube as well. with that, I'm gonna wrap it up and I'm gonna stop the recording. But for those of you watching the live webinar, I will stick around for a few minutes to answer questions. So thank you everybody for attending. I really appreciate you taking time in the middle of the afternoon, and I really appreciate your participation. So I'm gonna stop the recording now. Thanks so much.